We're ready to start the Zoning Commission hearing meeting for Thursday, November 7th. Could we get roll call, please?
Good morning. Commissioner Catholic,
Present.
Commissioner Kern,
Here.
Commissioner Kelly,
Here.
Commissioner Caliendo,
Here.
Commissioner Vandercourt,
Here.
Commissioner Ritter,
Here.
Commissioner Brumfield,
Here.
Commissioner Kennedy,
Here.
Commissioner Williams,
Here.
and a quorum.
Thank
Please
you.
rise for the invocation and pledge. Lord, we ask your guidance today as we consider matters that will affect the safety and welfare of many people in our county. Help us to listen with open minds to matters that are important before us and act on the matters that benefit those who reside in our area. Keep our minds open and alert, our hearts compassionate, and our comments charitable. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Zoning Commission of Palm Beach County has convened at 9 a.m. in the Vista Center, Ken Rogers Hearing Room, VC 1W47, 2300 North Jog Road, West Palm Beach, Florida, to consider proposed applications and staff recommendations pursuant to the Palm Beach County Unified Land Development Code. The Commission takes final action regarding Class B conditional uses, subdivision variances, and Type 2 variances, and issues advisory recommendations on other requests. The Board of County Commissioners of Palm Beach County will conduct a public hearing at 301 North Olive Avenue, West Palm Beach, Florida, in the Jane M. Thompson Memorial Chambers, 6th floor, at 9:30 a.m. on applications not subject to Zoning Commission final action. Zoning hearings are quasi-judicial in nature and must be conducted to afford all parties due process. The Board of County Commissioners has adopted procedures for conduct of quasi-judicial hearings to govern the conduct of such proceedings. The procedures include the following. Any communication with commissioners which occur outside the public hearing must be fully disclosed at the hearing. Applicants and persons attending the hearing may question commissioners regarding their disclosures. Such questions shall be limited solely to the disclosures made at the hearing or in the written communication made a part of the record at the hearing. Any person representing a group or organization must provide documentation that the person representing the group has the actual authority to do so regarding the matter before the commission. Any person who wishes to speak at the hearing will be sworn in and may be subject to cross-examination. The applicant and county staff may cross-examine witnesses. Any other persons attending the hearing may submit cross-examination questions, including follow-up questions to the chair, who will conduct the examination. The scope of cross-examination is limited to the facts alleged by the witnesses in relation to the application. Public comment is encouraged, and all relevant information should be presented to the Commission in order to be fair and appropriate decision to be made. We have proof of publication.
Yes, we do.
Motion to receive and file.
Second.
Motion received by Commissioner Caliendo, seconded by Commissioner Kearns. All in favor?
Aye.
Aye.
Motion passes. County Attorney, will you swear in those that wish to speak?
All those wishing to testify on today's quasi-judicial items, please rise and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Do I have a motion to approve the minutes?
Motion to approve the minutes.
Second.
I have a motion made by Commissioner Caliendo, seconded by Commissioner Kern. All those in favor?
Aye.
Motion passes. Do we have any amendments to the agenda?
I need to read into the record on item number 6, which is ZBPDD DOAW 2024-00309 for Central Park Commerce Center. We were advised that we had some missing conditions from Exhibit C2 for engineering as it related to some revisions for TPS, plating, and drainage. We discussed it with the applicant before the hearing, so we will add them into the record between now and BCC.
Thank you. And there's no request to pull items from consent agenda?
May I make a motion to adopt the agenda?
Before we do that, we have a comment.
They're just saying adopt the agenda.
Oh, adopt the agenda. I'm sorry, yes. I'm sorry. Commissioner,
Motion to adopt the agenda.
Commissioner Caliendo first, and seconded by Commissioner Kelly. All those in favor?
Aye.
Aye.
Motion passes. Do we have disclosures for items on the agenda? Starting with Commissioner Kennedy.
No.
I have disclosures.
Okay. Go ahead.
Should I go? She said Kennedy, and then...
I was just going down the
Down
line,
there.
yes, so,
Yeah.
yes.
Okay. Item 1, Dan Simpson. Item 2, Alex Chavez. Item 4, Josh Nichols and Dan Pelowitz. Item 5, Joseph Verdone. Item 6, Joni Brinkman. Item 7, Laura McClellan and Jennifer Morton.
Okay, thank you. Commissioner Brumfield, no? Kelly, no?
I spoke to the applicant on items 5 and 6.
Commissioner Caliendo?
None.
No?
I spoke to the applicant on item 7.
None.
No. And I spoke to the applicant on item number 7 as well.
Madam Chair, if I can just get Commissioner Vinacore to clarify, was that, were those verbal discussions or emails?
Verbal discussions
Thank you.
on the phone.
Okay, thank you. Do we have any conflicts or recusals, starting with Commissioner Kennedy and working our way down? No?
No.
No, ma'am.
None.
None.
None for my other. Do we have any postponements or remands?
We have no requests for any postponements, remands, or withdrawals.
Okay, thank you. On the consent agenda, I know there was Commissioner Vinacore had some comments she wanted to make, and we also have a public comment card. So I would like to ask the Kevin Whitmer to come up and speak on item number 3. Please state your name and address for the record, please.
Kevin Wetterman, 10178 Aqua Vista Way, Boca Raton, Florida. Good morning, everyone. I'm here on behalf of the residents of Meadow Lakes at Boca Raton. I think it's legally listed as Hillsborough Country Club. Community of approximately 300 homes directly west behind the proposed building that is in item 3 today. The residents have concern with the current configuration and lack of maintenance on the roadway in the area at Southwest 18th and State Route 7, and feel that the additional traffic that would commence with the construction of a drive-through restaurant would exacerbate that condition. I will say we are glad that there is a company willing to improve the area. We welcome that, but we would like the current conditions of that intersection evaluated. We have been in contact with state FDOT. They are not claiming responsibility for maintaining proper markings which are missing at that current intersection. I have also reached out to Code Compliance. They do have a open case that is currently being reviewed by zoning, I was told approximately 2 weeks ago. So it's a challenging intersection. The entry to the intersection from the community and the shopping center only allows for one car to stage at the traffic light among 3 lanes, and there are no markings indicating which lane should travel in which direction. So center lane can turn left, right, and when the center lane turns left, the left lane might decide to go straight, and there's a lot of dangerous traffic situations on a daily basis, including timing of the traffic light that only allows approximately 6 cars to pass through in the morning, and at times there's 15 to 25 cars lined up there, including school buses, and it's inconvenience and safety issue for the community and for the other people driving through the shopping center. So with that, I know I marked opposed on my my comment card, but we are happy that someone is going to be redeveloping that property and improving it. We would just like the county and the company to do their due diligence and make sure that the traffic markings in that area is appropriate for the volume that will be utilizing that intersection.
Okay, thank you very much.
So thank you very much.
If I may,
Question.
through the chair, I would like to state that there's a slip street in front of 5 properties north of the subject site up to Southwest 18th Street. And if the gentleman speaker would like to leave his information with zoning staff, we will sit down with him, engineering and land development, to address the striping and the arrows at the intersection that he was referencing. We could talk with him prior to the BCC meeting on the 21st.
Perfect. Thank
We
you.
have his contact information on there as well. Thank you.
Kevin, is this your phone number on here? Is this accurate? Yes, sir. Excellent. We'll make sure staff gets it, and they'll be in touch. Thank you for your comments.
Thank you. And with that, I know Commissioner Vinacore had some comments.
Oh,
on
yeah,
it.
just a few things. On item 1, the applicant is apparently going to hook into sewer. And I hope that that does happen, and I think that because of the expansion of the development, they'll probably have to do that. But in speaking to the applicant's representative, it was nice to hear that they're going to hook into the sewer. And on item 2, speaking to Ms. Chavez, I was concerned about the large footprint and the paucity of green space, but they assure me that there's going to be increased buffers and improvement there. And just lastly, with item 4, is Karen Cantor here from Solid Waste Authority? I think somebody was going to be. Hello, Karen. Okay, so it's real important to get them on board as soon as possible with the permitting, because they will need to, after you get your zoning and your health, you have to go to. So keep them informed, please. That's all.
Okay, thank you. Do I have a motion on the consent agenda?
Motion to adopt the consent agenda?
Second.
Oh, as amended.
Okay. All right. I have a motion by Commissioner Caliendo, seconded by Commissioner Williams, to adopt the consent agenda as amended. All those in favor?
Aye.
Aye.
Motion passes. Okay. Moving on to the regular agenda.
Okay. Items 5 and 6 ultimately kind of go together. Item 5 is DOA 2024-00313, PBA Holding, Inc. There is one motion and request with this relative to a development order amendment, and the companion application, item 6, ZB PDD DOAW 2024-309, Central Park Commerce Center, MUPD. There are 2 motions for a rezoning and a development order amendment. There are 2 exhibits. The staff recommendation says exhibit C1 through C4. It's actually just C1 and C2. So for a presentation from the applicant, we can turn it over to them and then staff.
Okay, thank you.
Good morning, everybody. My name is Joe Verdone. I'm with the law firm of Carlton Fields. I'm the agent of record for PBA Holdings, Inc. We are in agreement with the staff report and recommendation. I'm prepared to let Joni talk to you about what's going on with the property once it's being removed, but we are taking 64.46 acres out of a mine conditional use boundary, which used to be 5,096 acres. The resulting acreage is going to be 5,331 acres. So basically...
Could you speak closer to the mic? Sorry.
I'm sorry. So basically the resulting land area will be 5,031 acres when the 64.46 acres is taken out. There is no changes to the mine or mine reclamation or anything associated with the mine. This just enables the property to be rezoned and added to the Park of Commerce if you guys choose to do so. I don't really have any other more presentation. I just want to let you know that we are in agreement with the recommendations from staff.
Thank you. Does staff have follow-up?
Would you like a presentation? It's basically the deletion of 64 acres, as he had mentioned, that will be added to item number 6. The use as a batch plant will remain until time that they develop, but yeah.
Okay. Does anyone feel the need to see a presentation?
Can I just ask a question? Madam Chair, is this for just number 5 or number 5 and number 6?
Just
Right now, we're just talking about number 5.
Okay.
Okay. No presentations needed.
I'll motion to approve.
Motion to recommend approval.
Madam Chair, if I may just clarify with staff, these 2 items are dependent on each other? Okay.
So can we vote for one, or do we need to vote for them in their entirety together?
They're both in advisory in nature. The recommending approval of number 5 the final action is done by the Board of County Commissioners.
Okay. So,
if
sorry.
number 5 were not approved, number 6, and I understand that the recommendation is just trying to kind of understand. If number 5 were not approved, then number 6 would
Would
not.
be dead,
Okay.
yeah.
okay. All right. Thank you. I'm sorry. So do we have a motion to approve?
A motion to approve.
Second.
Okay. I have a motion by Commissioner Vinacore. I have a second by Commissioner Caliendo. All those in favor?
Aye.
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 Motion
Thank you very
passes.
much.
Thank you.
And if the agent representative for Central Park can come to the podium.
Good morning. Joni Brinkman with Urban Design Studio on behalf of the applicant. This is the second part of the request that Joe just spoke of. We're requesting a development order amendment and rezoning to bring the 64.46 acres into the already approved Central Park of Commerce MUPD. Just for location, we are located on the north side of Southern Boulevard, just east of 20 Mile Bend. This graphic shows you the existing MUPD that's already approved and entitled, about 138 acres. That includes the access to Southern Boulevard, also in red. And the 64.46 acres that we're proposing to incorporate into the overall MUPD is located south of and east of the access and the developable portion of the existing MUPD and west of the L8 Canal. Again, we're just asking to rezone the 64 acres to MUPD and to reconfigure the master plan to add the acreage. This application requires text amendments to the comprehensive plan as well as the change to EDC for this land use area, and that was transmitted by the Board of County Commissioners May 1st with a 7-0 vote. That included changes to the policies and the map, changing the land use to EDC, and also expanding the LUCIA, the Limited Urban Service Area boundary, to include this acreage as has previously been done for the approved MUPD. Again, that's exactly what the land use amendment was requesting. While we do have recommendation of support from staff on this, there are some conditions we're going to be speaking to later that we would ask for your consideration and input on. And I wanted to go over the conditions in the land use ordinance that's being amended because they do have some impact to those PREM conditions we're going to be discussing. The first one does not the first limiting condition in the land use ordinance had to do with traffic and the amount of square footage and trips that could be constructed on the property. We are not amending that condition. We are not proposing to increase that condition with this request, so there's no increase in intensity from a land use standpoint to what was previously approved on the 138 acres. We are deleting one condition of approval, which had to do with commencement of development, where the county has made a determination we have already commenced development with our infrastructure improvements, and so that is no longer required. Of note also, which kind of goes back to the PREM conditions, is the fact that residential uses are not allowed on this property. This property is in the Glades Area Protection Overlay, which prohibits residential development west of the L8 Canal. That was implemented to protect the agricultural areas to the west, and we will not be able to have any residential on this property. Again, land development permits have been issued on the existing MUPD, and the construction of the entrance road, the roundabout, and stormwater infrastructure is underway. The rezoning amendment, again, is the area you see here already has the MUPD designation and the EDC land use designation. And we are simply requesting to change the zoning from SA to MUPD to be consistent with the rest of the land area. For just a little bit of more context, the uses south of State Road 80 in this area really consist of, the sheriff's training facility to the left there and South Florida Water Management District. You'll see in your staff report that there are some uses on the 64 acres that are going to be vested and will continue to operate. They're accessory uses to the mining operation, which at this point I believe is valid till around 2036. They include asphalt and concrete batch plants. Those will continue to operate on this land area until such time as the mining operation ceases or the leases are terminated and new EDC use is constructed on that property. They will be considered legal non-conforming, and staff has agreed to that in your staff report. Again, this is just showing you the area of the Glades Area Protection Overlay, and it is the area west of the LA Canal that cannot have any residential development. That is already a limited service area for Arden. We are already a limited service area, and we will just be filling in that hole with the expansion. Again, surrounding uses, you've got Arden to the east of the LA Canal, the FP&L power plant to the west of the MUPD, South Florida Water Management District and the reservoirs to the north. Here's a representative picture of the existing FP&L facility, which is currently undergoing some expansion. Again, the surrounding uses in the area, FP&L to the west and South Florida, and the Palm Beach Sheriff's Training Facility to the south. I did want to point this out. Okay, the ULDC was amended some years ago to allow for the Board of County Commissioners to consider requiring a civic site dedication. The actual code language reads, the BCC may require that a portion of the gross acreage to the development be dedicated to Palm Beach County for public purposes when insufficient facilities are available to allow for the provision of government services required for the proposed development. No request for a civic site dedication was made of this project when the MUPD came through originally for the 138 acres. We are assuming because it was determined at that time that there was no need for services created by this development, and our position remains the same with the expansion of the 64 acres. Again, this is a non-residential development. It will not have residential units on it where you typically see civic sites for schools, fire stations, libraries, all of which actually are being constructed to the east of this property. There is an approved site plan that we're entitled to implement today for data center and warehouse uses, and we are not increasing the traffic associated with it. It's also the 64 acres that are of question are also located behind a large berm along Southern Boulevard. That was done in part to help screen the FP&L facilities from Southern and the traffic on there. The uses on the site, again, the FP&L Center, South Florida Water Management, the reservoirs, ongoing mining, and the asphalt batch and concrete plants will remain on the 64 acres for an unforeseen amount of time. No government services are required as a result of this project. The addition of land area does not create any additional need for those services. This is just a representative picture of that berm I was speaking to on Southern Boulevard. So it really inhibits any potential access to any civic site directly from Southern Boulevard. They would have to go through the heavy industrial uses that are already existing on the site and the future data center uses, which also require some fairly high-level security mechanisms to be in place. And at a point, the owner is currently in serious negotiations with the data center user. This just simply shows you the master plan that was approved and then the 64 acres that are being added along Southern Boulevard. There is an existing stormwater pond already constructed in that area as well that will be released in the future via a future replat. This shows the site plan that is already approved for the data center and a utility function on the bottom left of the screen with a warehouse already approved, entitled, and allowed to be constructed today. and again, the 64 acres that are going to be incorporated into the site plan. The site plan is allowed to be amended later as users come on board, and that will be done via an administrative process. In regards to a potential civic site dedication, again, that brown area to the left is already entitled for our MUPD, where we have the ability to construct our approved intensity. So in our opinion, that should not be considered in any of these discussions. And the brown to the right are the batch plants, the concrete and asphalt batch plants, which will be remaining on site for, again, a considerable amount of time we're anticipating. And the blue to the north is that existing pond, and the green and blue to the south are off-site drainage facilities that are also associated and approved with plats for this development. I don't know why that's in there again. Am I going forward? So staff is recommending approval. We agree to all the conditions with the exception of PRIM conditions 1 through 4. We are asking a recommendation from the Zoning Commission that the BCC not require a civic site dedication specifically for this project, because we do not feel this project is creating any need for any additional government services. That ends my presentation. I'm sure there will be questions. We'll be available. And I believe staff probably has a presentation.
All right, thank you.
Mm-hmm.
Good morning. Good morning. I'm Sabita Prasad from the Zoning Division. Here to present the two applications, item 5 and 6. Oh, just 6. That's right. We did 5 already. So I'm probably going to repeat some of the same things that the agent has already explained. Central Park of Commerce, PDD DOA 2024-309 is the application number. It's for the same, it is the same owner for both applications and the same parcel, just deleting it from one and adding it to the other. The future land use for the Central Park is RR10. So the applicant is asking for a rezoning from the RR10. The future land use has the LGA, a concurrent LGA that is going to change the flue from RR10 to EDC. And they're also asking for a rezoning for the parcel, subject parcel from SA to MUPD. And that will make it consistent with the existing development order. The preliminary master plan for the Central Park of Commerce is being revised at this time to add the land area only, and the site plan will be amended subsequently in the future when the applicable EDC uses are established. The Central Park of Commerce MUPD has an existing approval for 2,020,000 square feet of warehouse and data processing center as EDC uses. The addition of this parcel will allow future expansion of these EDC uses. In accordance with the proposed conditions of the large-scale amendment, the site can expand with the allowable EDC uses to a total of 3,278,000 square feet. At the time of publication, staff has received 6 phone calls from the public just asking for clarification and more explanation on what the project is with no objections. Staff recommends approval of the request subject to the conditions of approval in Exhibit C1 and C2. This concludes my presentation. Thank you.
I'll make a correction. The future land use amendment has a restriction on the square footage, 2,700,000 and something. They won't get up to 3 million, so that is incorrect.
Okay, thank you. All right, do we have comments from the commission? Comments, questions? Let's start with Commissioner Kennedy. Do you have anything? No? Okay, Commissioner Vinegar.
Yeah, a few things. About the civic site dedication, we can't let that go. It would have been 4 acres altogether, correct, with the previous parcel and the 2.77 acres from the previous parcel, and then 1.29 acres from the 64-acre, correct? It would have been 4, and I can see that with the previous approval that we'll let that go, the 2.77, but the 1.29 that we're discussing here, I know I discussed with Joni, we have this sheriff's firing range there. It is owned by the Palm Beach County. And I see I have facilities here. So comment, go ahead, please.
I was afraid you would never ask.
Great.
Good morning, Madam Chair and zoning commissioners. For your record and as an introduction for those of you I don't know, and as the proverbial elephant in the room, I'm Eric McClellan. I serve as the Director of Strategic Planning for the county's Facilities Development and Operations Department. Typically, you would hear from us on civic sites associated with PUDs, planned unit developments, or perhaps even our own zoning applications. But what we have today is a bit of a unique circumstance. What you saw from Ms. Brinkman is that there is a provision in the county's MUPD regulations that does provide the Board of County Commissioners the opportunity to require a dedication when there are insufficient facilities to serve the proposed development. Using that plain language, staff does not pretend to be the Board of County Commissioners. We will defer to the Board of County Commissioners, but we do feel it's our professional obligation to raise this opportunity to their awareness for direction and decision. So with that, based upon a combination of institutional knowledge as well as outreach and coordination to end users, we have identified interest from Palmtran in a park and ride facility at this location, which would be the midpoint between their eastern and western points of service along their Southern Boulevard route. We've also become aware recently of a truck parking deficiency issue in the central western communities that has received some interest and some attention, and the fact that this project will have over 2 million square feet of industrial entitlement. We feel there's reasonable potential for additional truck parking needs to arise as a result of the project. And then also there was reference earlier to the PBSO Sheriff Shooting Range. Over 200 acres approximately around that facility have been directed by the Board of County Commissioners to be put on the street through an RFP for a potential race or OHV park. So leveraging the transportation assets that could occur here, we feel that there could be some possible utilization as well. So really the threshold question here is, does the board see this as an opportunity to require a dedication? And I do not speak for the board. If the answer to that question is yes, at the board's discretion, the next consideration becomes the acreage. And as Ms. Vinacore was alluding to, typically you would apply a 2% standard to the affected area of an application. Applying that to the roughly 64 acres in this case would yield about 1.2 acres. From our experience, 1.2 acres really is deficient to deliver any public facility. And in the ULDC, we have a standard of 1.5 acres from which to require a dedication. However, with the companion land use and text amendments, that is a vehicle for the board to determine the acreage that they would like to identify should they see this an appropriate and responsive opportunity for a dedication. So with all of that as background, the conditions that are on pages 13 and 14 of the staff report do reflect the hypothetical 4.5 acres if the board were to decide they wanted to apply that to the entire property as a condition of the land use change that is being requested. That acreage figure obviously could be adjusted downward, upward, or the conditions deleted altogether at the BCC direction. So that is essentially the story. Happy to answer any questions at this time or as you further deliberate on the application.
Okay, Eric, for your great extemporaneous speech. You were prepared very well for this. Thank you so much for explaining that. That's great. But even with 1.29 acres, what about for, they were concerned about FSMA, So with the public record storage, that can comply with FSMA. A PBSO satellite office can comply with the FSMA. Or what about the 1.29 acres for the employees that are there so that they don't have to worry about the Federal Information Security Modernization Act? Okay, so it could be used just for the people there. Besides that, an MUPD can have a work-live component. Now, I understand this is in the GAPO, but the comprehensive plan can be changed. It can be amended to allow living, working just on this particular parcel, because that's part what an MUPD is allowed to have.
Excuse me, that's not before the board today. Hypothetical discussions of future comprehensive plan amendments are outside the scope of the zoning commission.
Okay,
So this is a quasi-judicial proceeding for which decisions are required to be based upon competent, substantial evidence presented at the actual hearing, not hypothetical future. This is not a legislative role of this board. It's quasi-judicial. I would recommend against discussing future comprehensive plan amendments that are not beyond the scope of this board. Thank you.
Okay, so that what could be here would be record storage. Could we have satellite office, and that wouldn't interfere with the issue of the FISMA. Eric, does Palm Beach County, can they use record storage, or something that people would feel more secure here having something?
So that was a lot to digest and chew on. Let me first directly address that question. I think Ms. Brinkman did a good job when she presented the language that's in the ULDC, and there does need to be a connection to this project. That's why, as part of our outreach, we were looking at, transportation issues. Are there potential for Palmtran passenger riders associated with the 2 million square feet? We would think there is. We're working to quantify what that might be. So when it comes to other facilities, I don't see the direct connection. I don't think it's underserved in this area. We haven't identified that as a need, so we are talking other uses. I also want to build a little bit upon what Lisa shared, just to be completely transparent when we're talking about residential uses. There is the land use prohibition on residential in this case, for one. And secondly, we did recently have a workshop of sorts with the County Commission regarding housing in civic dedications, and the direction was not to utilize those dedications outside of the urban-suburban tier for housing. So this being outside of the urban-suburban tier, I wouldn't see that aligning with their direction to us.
Yeah, well, I wouldn't see the live work there on that parcel. It would be within the other part of the MUPD. This parcel would be for possibly recreation for the employees. That's fine. I'm
Chair,
no
can I
enough.
ask
Thank
a
you.
question?
Yes, you may.
I have a question, I guess, for Lisa. Isn't this out of our scope? Shouldn't this be left up to the way it reads, for me, that it should be left up to the county commission? Having these discussions here is totally inappropriate.
Well, the Unified Land Development Code language is on the screen right now, and that's what Joni presented. It says the BCC may establish a civic pod. There is no published staff report with a future land use amendment condition of approval, but we do have the proposed condition at the bottom of this screen that would move forward in tandem when we go to the Board of County Commissioners this month. So in order, there's 2 points of view. This is an advisory recommendation by this board, and you're required to consider the evidence presented to you today. And your decision would be, does this proposed civic pod in the zoning arena meet that requirement of which shown on the board and the screen where it says Article 3, civic dedication? So you can recommend that you feel that MUPD context civic dedication is required, or you can defer to the Board of County Commissioners. So it's your call whether or not you want to go with the recommendation of Joni, which is somewhat in line with the recommendation by the county that this is a conversation at the Board of County Commissioners.
I agree.
So there is no harm, no foul if you defer, or when we go to the Board of County Commissioners, we relay to the board that it was in or out of your recommendation based upon ultimately their decision. So it is to some extent outside the purview, because this board does not weigh in to conditions of approval at the future land use atlas or comprehensive plan amendment stage.
That was my point. Yeah,
And
thank you.
just to add on to that, to supplement that, Lisa's correct. It's a little bit difficult to make a decision based on a future land use amendment which hasn't even been published yet, in the agenda. But you have enough information here that I think would provide, a sufficient amount for you to understand what's going on. The reason why it would be appropriate for you to discuss it is because there are zoning conditions of approval which are requiring this 4.05 acre dedication. So because it's part of the conditions of approval in this particular application, it's appropriate to discuss that and ask questions and better understand how everything kind of connects, together. But yes, ultimately, the language is clear that the board, would be the one making that decision. But at the same time, the board is always the one making the final decision on these types of applications. So you have a right to provide input within the scope of the application.
Did you have a comment, Commissioner?
Yeah, I think I would like to approve with the civic dedication proposed approval. I think it's important that we have one out there, especially if Palm Tran has interest in it and being a point of a stop.
Is that a motion?
I had a question about that because I saw that in the comments, Palm Tran did not have any comments, although it was recommended to do a Palm Tran stop. So I was a little confused as to whether Palm Tran did want to stop or did not, because it did say that they didn't have any comments. So if somebody could address that.
Not Palm Tran, but I'm happy to speak to that and respond to it.
So somebody from Palm Tran might be here.
And I will let him take the stand.
Good morning, Madam Chair, board members. My name is Bruce Guyton. I am a senior transit planner with Palm Tran. I've been with Palm Tran for 22 years. I've been with the county for 26. As it relates to the question about our interest, Palm Tran interest, we do have an interest because, as most know, the traffic congestion is increasing. We need options. And one of the options that we think would be viable is for us to have a park and ride where we can reduce the traffic on the streets, or a transit hub so that we can increase the frequency of our routes going west. So as it relates to traffic congestion and options to deal with that, because as you all know, we can't build too many, let me say that, it's limited space to build more roads. So public transportation is our next option, and this will assist us in addressing that problem. I entertain any questions.
Thank you. Any questions?
So with that, my motion stands.
Okay. All right. I had just one other comment, and I don't know, Joni, this might be for you. With regard to the way I read it, and Laura, you broke it down as well, the percentage, the 2% on the 64 acres versus the 2% on the larger part. So the way I read it is you're looking for, right now, 1.29 acres, but
Well-
you would prefer not to have any, right?
Right.
Based on the location. But I guess my question is, there's a balance between smart development and also taking care of the community, right? So it's a good balance. So what I'm trying to understand is, it looks like we're looking to, correct me if I'm wrong, to do the larger portion, the 4 acres. Is that what?
The
4
4
acres.
acres.
Can I just ask if that would, how much of an impediment that would be to the development?
I think locating and not knowing what the use is going to be problematic by giving that amount of acreage. And again, I think our position is, if you're considering making a recommendation and you want to support it, we feel for sure it should not be applicable to the entire MUPD. It should only be applicable to the land area we are bringing in. We're not increasing the intensity of the development, so that would actually equate to 1.29 acres. And just to follow up on a couple of the potential uses that Eric brought up, I know he brought up truck parking for people in the acreage. I just want to point out that the civic site uses are to be for governmental services, and at this point in time, it doesn't appear that would qualify. As I think Lisa had brought up, we were not aware till recently that Palm Tran had an interest in this, but the bottom line is we do not feel it should be applicable to the 202 acres, so it would be at most 1.29, and we would request the board to consider potentially amending the condition in that regard.
Okay, thank you.
And Madam Chair, if I may just add on to that a little bit of some additional context. And it was mentioned in the presentation, and Eric brought it up too as well. Whenever the board is considering what we call an exaction, in this case, a request for a fee simple dedication or a monetary exaction, there's really two prongs to look at. One, is there a nexus between this condition and a legitimate governmental purpose? And I think, Prem did a good job, Eric did a good job explaining, what that potential governmental purpose could be. And the other thing is that the condition, the request, in this case the 4.05 acres or whatever the acreage may be, has to be roughly proportionate to the impact caused by the development. And so, again, we're at this kind of situation where the condition for the flu hasn't yet been published. We don't know exactly what it's going to say, but there does need to be a demonstration of this connection between the requested acreage and the impact being caused by the development.
Okay, thank you. So with that, any more discussion, or if we're going to move forward with the motions? Move forward with the motions, okay.
I think we have a motion and a second.
We do, yeah, I just did do, yep. So we have a motion by Commissioner Reichter and seconded by Commissioner Kennedy. All those in favor?
Aye.
Aye.
All those opposed? I'm going to say nay on that, so motion passes.
There's two motions, 6A and 6B.
Oh, 6A and
6B.
Oh, okay.
You need another motion?
Yeah, need another motion on 6B.
Motion to accept 6B as stated.
Second.
Second. All right. Motion by Commissioner Caliendo, second by Commissioner Reichter. All those in favor?
Aye.
Aye.
Motion passes.
Was that 9-0?
Yep. That concludes the regular. Oh, no, it does not. I apologize. I'm ready to go.
Okay, that brings us to the ULDC revisions. Item number 7 is the agriculture marketplace in a preserve modification, and we have Jerome Oddie to provide a summary of this.
Actually, we probably can get past without a presentation. This is a text amendment that we're proposing to the ULDC to implement a comprehensive plan amendment that was adopted by the Board of County Commissioners. So this will just transfer that language from the comp plan into the Unified Land Development Code. So if you have any questions, I don't believe the applicant is here that presented this at the Board of County Commissioners. Maybe they're here. Oh,
Yeah,
they are here.
the applicant's here.
Alex. Yeah, there we go.
Okay.
Yeah, so I'm happy to present if you want a presentation. It'd be really quick.
I don't
think we
need
need
a presentation.
Okay.
I do believe there
I'll
might be
motion
some questions.
if you'd like.
Yeah, go ahead.
I motion to approve.
I second.
Okay, got a motion by Commissioner Vinicor, second by
Can we separate those into two separate motions?
7A and 7B.
Oh,
I didn't see that.
Yes.
It's not on my page.
all right.
I'll separate it into two separate motions, yes.
Okay, so agreeing on first 7A motion.
7A, I motion to approve.
Second.
Okay.
And-
And 7B?
7,
Okay, and
Second.
Okay, so motion made on both by Commissioner Vinicor and seconded by Commissioner Reichter. All those in favor on 7A?
Aye.
Aye.
Okay, motion passes. All those in favor on 7B?
Aye.
Okay, motion passes.
Yeah, right.
Okay, item number 8. This is a modification to the ULDC as it relates to our flood damage prevention ordinance. And we have our lovely members from our building division here to give a summary of this. Doug, would you like to go through? And any comments from the board we would like on content. If we have questions on punctuation or capitalization, you guys can email us and we can go through that before the Board of County Commissioners. But any comments on the language, if we could have it on the content?
Thank you, Wendy. For the record, Doug Wise. I'm here with Jackie Anderson, our certified floodplain manager. We're here presenting the changes required by FEMA for the new ordinance that has to be adopted as part of the flood map update. Jackie can go through the specifics. I think you have a PowerPoint with summary background lines it up. Jackie, go ahead.
So in February of 2020, FEMA issued a policy explaining how agricultural structures in non-habitable accessory structures are considered non-residential, and the majority of communities in the NFIP had not been properly enforcing the design and performance standards required for those buildings. So the policy stated that any building that is an agricultural building, enclosed or partially enclosed, meaning a minimum of 2 walls and a fixed roof, would require to be elevated or dry flood-proofed, as opposed to wet flood-proofing. Wet flood-proofing is flood openings that allow water to go in and out of the building. Elevation is self-explanatory. Dry flood-proofing would be making those buildings watertight. If a building was supposed to, or if a person wanted to wet flood-proof, they are supposed to go before the Flood Damage Prevention Board to obtain a variance. So the changes that are being made to Article 18 are to basically require a variance for any agricultural structure or non-habitable accessory structure for wet flood-proofing. One of the other requirements that we had to change was for the community rating system, which is a incentive program, voluntary incentive program that the county is part of. Palm Beach County is currently a Class 5. There was an addendum to the CRS Coordinator's Manual in January of 2021 that required that the foundation and elevation requirements for manufactured buildings needed to be modified. So in order to maintain our Class 5 rating and not be retrograde to a Class 9, we are implementing those changes. The next thing would be the Florida Building Code modified size or added size limitations to these non-habitable accessory structures that would be allowed to be wet flood-proofed without a variance. So we are basically implementing the same requirements. And the final thing is with the map updates, the county has now new coastal flood hazards that we are going to be adopting, like the limit of moderate wave action and coastal A zones. We are going to be implementing the same design and performance standards for a V zone, which is a high wave velocity zone, for those coastal A zones, because the coastal A zones will see wave action between 3 feet and 1.5 feet. So that's basically the summary of the changes that are being made, along with adding some new definitions and clarifying some things.
Thank you. Any comments from the commission?
Nope.
Yes. Can I be heard? Okay. Great job, Doug Wise. You have an excellent staff there. Can you tell me why, with the substantial damage, page E4, that you changed it from 50% to 45%?
Yes. So currently, the county has already implemented a 45% as a contingency to allow people to make changes without meeting that 50% threshold, which would require them to bring the building up to current standards. In order to get an additional credit under CRS, we are allowed to go ahead and make that, since we're already enforcing it anyway as a contingency to help people, we can actually make that or codify it so that we get an additional CRS credit. But it also, if someone wanted to, if they didn't want to abide by that 45%, it's not a hard line where they would not be able to go to the Flood Damage Prevention Board to get a variance from the county's higher standard. So FEMA, it's a hard line at 50%. The county's been enforcing 45% to allow that 5% gap in case of unknown things that might pop up during their improvements.
It's basically a contingency allowance if you're, say we issue the permit and it's right at 50% and they start the work and they run into something that's going to increase the cost, we're in a situation where we can't approve the change that's going to increase the cost. So we don't want to let a customer lead them down that road and get them to a place where they can't go. So that's why we've done it informally. We'd like to formalize it, and we'd get some credit for that too. Will help a little bit with our CRS points.
Oh, thank you very much. It's a great explanation. Can you also explain why you use millimeters in like talking about wave height, but it's not consistent throughout that when we speak about other things that are 2.5 feet, you don't use millimeters. Is there some reason why? Is it something international about the wave height?
I don't really have an answer for that.
I wasn't aware of that. We'll have to go back and look at that.
We got that language directly from the Florida Division of Emergency Management. We literally copied and pasted from their recommended language.
Okay, because there you use the millimeters, but then in other parts of it, like 3 or 4 other parts, it only talks about feet or inches. So, okay. Just one other thing, can you explain on page E16? I just didn't understand the sentence. Page E16, number 22. The accessory structures are used only for parking or storage and the accessory structures. Just wonder what that means.
I'm pretty sure that it may be just a syntax error or something redundant. There's been a lot of chopping and hacking on this ordinance. We were trying to put language together from the original Article 18 that we inherited from the county with the model Florida Department of Emergency Management ordinance. So we've been folding stuff into this for a while.
That was just extra.
If there's a problem, you just send it and we'll fix it. We went to first reading. We can fix it before second reading.
Thank you very much. This is a great job, a beautiful work of art.
You can make a motion.
Make it so far, she said.
I have a question for on agriculture structures specifically, but I guess it applies to accessories also. These are requirements for new builds, correct? For the wet proofing, especially wet proofing.
New and substantially improved.
Right. So same thought process. My question is that we're not requiring any kind of retrofit for existing structures. Say, for instance, someone has 20 acres and they get a permit for a new accessory structure on their property. They're not going to be required to retrofit anything else that's already existing on their property.
No, so this would be for new buildings or buildings that are being substantially improved.
Yeah, if it's attached to the building, we're required to make the whole building comply.
Right.
So what they call structurally attached. So you could have a breezeway and it's not physically attached through structure, but in the case of each structure has to stand on its own.
Right. I've just had some experience with folks in neighboring communities who've had to actually retrofit their barns to have the wet flood proofing construction added to them after code compliance came to them.
Code compliance, correct. So if there was a building that was erected without a flood damage review, then I do believe that code compliance is.
Yeah, I mean, I had speculation here, but if they came to us and they had to retrofit, it would be unpermitted work. It would be the reality of it. So code compliance brings us unpermitted work every day, and we have to figure out how to make it work. So that would be my guess. If you have a specific case, you want to email it to me, I'll look at it and find out. But it doesn't affect existing stuff on legally permitted farms. It would not have any effect. And legally permitted accessory structures. We historically, let me say for the record, historically we have always allowed wet flood proofing on accessory structures to residential. We've also allowed it historically on agricultural. FEMA came out with a new policy memo in 2020 and blindsided us. And it wasn't just us. It was like 67 counties and everybody in the state of Florida. It was FEMA and Florida Department of Emergency Management. And, they're coming around now looking at every new ordinance that comes out and insisting that language be there. So we are doing our best to adhere to the policy to make federally backed flood insurance and mortgages available to the community, but at the same time, it's like it's painful.
Mhm.
It really is.
And the reason I brought it up is because I've had some experience with unpermitted structures before, because bona fide agriculture didn't need to have permits for structures until some time ago. So there are existing structures that are unpermitted, and I'm just looking at the burden that folks might have if code comes on their property, or an inspector comes on their property and sees a structure and says, well, what about that one?
Right. I mean, bona fide agricultural structures they are exempt from the Florida Building Code, but not from floodplain regulations. And so there is a possibility during code compliance rounds that they might find a building that was not reviewed for floodplain regulations. We would prefer not to see those buildings, because then we have to regulate them according to the current flood zones. And when you have something that was built in the acreage, before the maps changed in 2017, now they may not be compliant because, thousands of acres were placed into a special flood hazard area that were not there previously.
Right. That's just trying to figure out where to expect some blowback is all. Thank you.
Can I make a motion to approve?
Second.
If I may, just kind of piggybacking on what Wendy said at the beginning regarding the grammar and the spelling, I do think it is very beneficial to handle those things in an email or something, because you can highlight exactly what you're talking about. But to the extent that anybody had an expectation today to mention anything about grammar or punctuation, I hope everybody feels free to express those thoughts.
Okay.
Okay, a motion and a second.
We have a motion
And a second.
on. There's two motions to be made, so I don't know. Thank you. Motion on item A, 8A. Is that your
Make a
motion?
motion to approve item 8A.
And
Second.
Okay. All those in favor?
Aye.
Okay. Motion passes. Commissioner Riker and Commissioner Caliendo first and second, sorry. And then do I have a motion on
Motion
item-
to approve 8B, the zoning commission serving as the land development regulation commission.
Okay, I have a motion by Commissioner Venacore, seconded by Commissioner Caliendo. All those in favor?
Aye.
Aye.
Okay, motion passes. Any comments from anyone? County staff? No? Okay.
I would like to call your attention to attendance. It is in January of this year, where if any commissioner has not met their attendance requirements, which is 67% of the meetings of this year, you'll have to be administratively removed from the board and then potentially get reappointed. So at the discretion of the Board of County Commissioners, so I highly encourage you to review your attendance for the year and attend in December if there's any question or not, if you could attain the 67% compliance. And have a wonderful Thanksgiving, and we will see you in December.
Thank you.
Thank you so much. Do I have a motion to adjourn?
Motion to adjourn.
Motion to adjourn.
I have a motion to adjourn by Commissioner Caliendo, second by Commissioner Venacore. All those in favor?
Aye.
All right. Thank you very much.